The feminization of teaching and nursing had occurred because such work was seen as extension of the nurturing work that women do within home. Which of the following best describes this statement? An analysis of women's majority in teaching and nursing, a description of teaching and nursing profession, a compliment to women as nurturers, an ironical take on teaching and nursing. In this question, the correct answer is option 1, an analysis of women's majority in teaching and nursing. Now let us see the question number 27. Question number 27 is related to the passage. Read the following passage and answer the question from 27 to 31. They had been camping in this part of Africa, undergoing exercise to familiarize themselves with the African war in grasslands and small dense forests where the rule was fire first and apologize afterwards. In this land of swamps, they lived among large mosquitoes that outnumbered them by 1,000,000 to 1. There were deaths from malaria. The condition of the white troops was worse because they fell victim not just to malaria but to diarrhea and skin diseases as well. Many died without firing a shot. Question number 27. Swamp means options are forest, marshes, hilly regions or river. In this question, correct answer is marshes. Swamp means marshes. Question number 28. They need to familiarize themselves because Africa is a difficult terrain. There are many forests in Africa. They have to kill mosquitoes. They are not used to the terrain. Correct answer is option 4. They are not used to the terrain. Fire first and apologize afterwards indicates they don't care for consequences. Their lives would be in danger if they did not fire. They are unapologetic. They have to learn to apologize. Here the correct answer is their lives would be in danger if they did not fire. How many die without firing a shot? Option 1, they were killed by diseases. Option 2, they were killed by their enemies. Option 3, they died because of tough terrain, and option 4, mosquitoes killed them. In question number 30, correct answer is option 1, they were killed by diseases. Exercises implies sports, running, military exercises, fitness training. Here the correct answer is military exercises. Read the following passage and answer the question from 32 to 36. At the end of the 20th century, we were living in a world saturated with music. Sounds accompany us everywhere, and particularly when we are waiting in closed spaces, whether on telephone, on an aircraft or at the hairdressers. The consumer society seems to consider silence a crime. So music has nothing to fear in the 21st century. Admittedly, it will sound quite different by comparison with the 20th century. Present day world has already been fundamentally revolutionized by electronics, which means that it is already largely independent of inventive talent and technical skill of the artistic individual. Question number 32. Revolutionized means made independent, made more interesting, radically changed, used for revolution. Correct answer is radically changed. According to the author, music in the 21st century is more blaring, is not pleasant, has become more popular, is more electronic and less dependent on individual talent. Here the correct answer is more electronic and less dependent on individual talent. The consumer society seems to consider silence a crime, is irony, insulting comment, angry reaction and satiric comment. Correct answer is satiric comment. Question number 35. 21st century society is characterized as more interested in music, revolutionary, consumerist, close. Correct answer is consumerist. Inventive means angry person, a person who makes inventions, artist, creative. Inventive means a person who makes inventories. Now let us see the question number 37. B is a person of unsound mind. A hands over a petrol soaked piece of cloth afire to him and instigates him to throw it into the car of C. B complies. As a result of the car is destroyed in fire. A and B are prosecuted on the charge for offense of mischief. Here both A and B are guilty because the acts committed show they had agreed to an illegal act. Only B is guilty because A had not set the car on fire. Only A is guilty because he instigated B to commit the act. Both are not guilty because B did not have the mens rea and A is not responsible for actus reus. Answer will be option 3. Only A is guilty because he instigated B to commit the act and B is the person of unsound mind. So B will not be the guilty. B will come under the exceptions of IPC. Now let us see the question number 38. A has engaged in services of B, a financial planner, to make investment on his behalf. A remits rupees 10 lakhs to B, asking him to purchase stocks in company X. B, finding investment in company Y to be possibly more lucrative, invests the money in purchasing its share. Company Y goes into liquidation, resulting the losses. Here B is guilty of the criminal breach of trust. B is guilty of dishonest misappropriation. B is guilty of cheating. B has not committed any offense. Correct answer is option 4. B has not committed any offense. Now let us see the question number 39. In someone's case instituted otherwise than upon a complaint, where the Metropolitan Magistrate stops the proceeding under section 258 CRPC after the evidence of principal witness has been recorded, he may option 1 release the accused, and such release shall have the effect of discharge, pronounce a judgment of acquittal, either discharge or acquit the accused, discharge the accused only on the request of the accused or his counsel. Correct answer is pronounced judgment of acquittal. This question is related to section 258 of CRPC. Section 258 of CRPC says about power to stop proceedings in certain cases. In any summon case instituted otherwise than upon complaint, a magistrate of the first class or with the previous sanction of CJM, any other judicial magistrate may, for the reasons to be recorded by him, stop the proceedings at any stage without pronouncing any judgment, and where such stoppage of proceedings is made after the evidence of the principal witness has been recorded, pronounce a judgment of acquittal, and in any other case release the accused, and such release shall have the effect of discharge. So option second is the correct answer. An accused can be examined as a witness for the defense and give evidence of a trial under section 315 CRPC only where option 1 the accused makes an oral request that he be examined as a witness. Option 2 both the accused and his counsel make an oral request that the accused be examined as a witness. Option 3 the accused himself makes a written request that he be examined as a witness. Option 4 when the court feels that there is substantial evidence against the accused and therefore the accused must lead evidence. Here the correct answer is the accused himself makes a written request that he be examined as a witness. Section 315 of CRPC says accused person to be competent witness. Option third is the correct answer. Now let us see the question number 41. Which of the propositions is not correct with regard to the period of limitation specified in section 468 CRPC for taking cognizance? Options are the period of limitation is 6 months for offences punishable with fine only. Option second, the period of limitation is 1 year for offences punishable with imprisonment for a term not exceeding 1 year. Option 3, the period of limitation shall be 3 years if the offence punishable with imprisonment for a term exceeding 3 years. And option 4, the period of limitation in relation to the offences tried together is determined with reference to the offence which is punishable with the most severe punishment. Here the correct answer is option number 3. The period of limitation shall be 3 years if the offence is punishable with imprisonment for a term exceeding 3 years. Section 468 of CRPC tells about bar to taking cognizance after lapse of period of limitation. Now let us see the question number 42. Which of the following acts done by the Metropolitan Magistrate while not being empowered by law is not an irregularity vitiating the proceedings under the section 461 of CRPC? Tries an offence summarily, tries an offender, demands security for good behavior, pardons the offender. Here the correct answer is option 4, pardons the offender. Section 461 CRPC tells about the irregularities which will vitiate the proceedings. Now let us see the question number 44. Which one of the following is not a class second heir as per schedule to the Hindu Succession Act 1956? Options are daughter's son's son, option second daughter's son's daughter, and option 3 father's father, and option 4 daughter's daughter's son. Here the correct answer is option 3, father's father will not be the class second heir as per the schedule to the Hindu Succession Act 1956. Now let us see the question number 45. A will is proved by filing and proving the original will. There are however exceptions to this rule. Which of the following exception is correct? Options are: if the original will is destroyed by the testator, then a certified copy of the registered will can be produced and proved. Second option is where the will has been torn by the testator, but before tearing the will, he has given a copy of the will to each of the beneficiaries and one of the beneficiaries produced the said copy. And option 3, if the original will is lost by accident after death of the testator and a copy is produced by one of the beneficiaries. Option 4, if the original will was revoked but was on a non-judicial stamp paper and signed by the two witnesses, then any one of the said two witnesses can produce and prove a photocopy of the will. In question number 45, the correct answer is option 3rd. If the original will is lost by accident after the death of the testator and a copy is produced by one of the beneficiaries, probate of a will is compulsory in Delhi. If the will is executed in Delhi for immovable properties situated outside Mumbai or Kolkata or Chennai, if the will is executed in Delhi and properties are located in NCR of Delhi. Option 3, if the will is executed in Delhi and the will appoints an executor under section 222 of the Indian Succession Act. And option 4 is not a correct statement. In this question, none of this statement is the correct statement. An ex parte letters of administration granted with respect to a will can be revoked. Option 1, only under section 263 of the Indian Succession Act. Option second, can never be revoked. Option 3, only when conditions of Order 9 Rule 13 CPC are satisfied because section 263 of the Indian Succession Act does not apply. And option 4, none of the above. In this question, correct answer is option 1, only under section 263 of the Indian Succession Act as an ex parte letters of administration granted with respect to a will can be revoked. Now let us see the question number 48. Probate or letters of administration granted by the district judge in one state will have operation throughout the country with respect to all properties wherever situated. Option 1, yes, provided the judgment of the district judge is upheld by the High Court in an appeal. Option 2, yes, if the value of the properties estate outside the territorial jurisdiction of the district judge do not exceed sum of 2 crores. And option 3, yes, if the value of the properties outside the territorial jurisdiction of the district judge granting probate do not exceed a sum of rupees 10,000. And option 4, yes, provided there is a notification by the central government that the judgment of the district judge will apply throughout the territories of India. In this question, the correct answer, option 3, yes, if the value of properties outside the territorial jurisdiction of the district judge granting probate do not exceed the sum of rupees 10,000. Now let us see the question number 49. Ceremonies of Hindu marriage: B, Sapinda relationship, C, void marriage, and D, voidable marriage. Ceremonies of Hindu marriage, section 11 of the Hindu Marriage Act. Sapinda relationship is provided in section 5 of the Hindu Marriage Act. Void marriage is provided in section 7 of the Hindu Marriage Act. Voidable marriage are provided in section 12 of the Hindu Marriage Act. Question number 50. Where the wife files a petition for restitution of conjugal rights under section 9 of Hindu Marriage Act 1955, on whom lies the burden of proving reasonable excuse for withdrawal from the society? Options are petitioner wife, respondent husband, family members of the wife, family members of the husband. Here the correct answer is option number 2, that is respondent husband. This is the correct answer, respondent husband.